1905.
I'll just follow up really quick, Matt, and maybe this is where to go. And I think that Sig makes a good point, which is that, we've mostly, I think, been, giving everyone the bad news here. The bad news is, I think we're all aware of how frustrating the assertion of state power is in this case. And I think we're all keenly aware of the economic damage that is resulting from the whole situation, and how much of that you want to attribute to the government's actions or to the crisis itself is a fair game, and there's a lot of room for debate. And I'm sure that we all have disagreements with the categorizations that have been made in some of the government's orders so far. And the closer you can get to demonstrating a truly arbitrary distinction between businesses, the better off a chance you are maybe of challenging this. And one that springs to mind, for example, and I'll admit that I haven't gone to the next level and looked at the regulatory guidance on this, but I know, for example, right now the scheduled reopenings distinguishes between bars and restaurants. And it's not entirely clear to me that in all cases that is any somewhat arbitrary distinction, because whether or not one is a bar or a restaurant doesn't really have a lot to do with necessarily how closely people are packed together or how the virus might be transmitted in a particular space. So theoretically, there might be room to make challenges around the edges of these orders, particularly to the extent that you think one class of people is being characterized differently than another, totally inconsonant with the risks. And I see someone in the chat has brought up the Ebola quarantine case from a few years ago under Governor LePage. That case ultimately settled, but the initial ruling by the Superior Court in that case found that the quarantine order on her was overbroad, and it did so based on the view that the quarantine restrictions that were being imposed were only consistent with an airborne transmission, and there just simply wasn't any evidence in that case of airborne transmission of the Ebola virus. So it felt that the restrictions were overly broad, but it did uphold the ability to impose some restrictions even in that case. I also just think that the reality of, a few examples of Ebola, which, perhaps justifiably were causing a lot of concern, are just not going to be treated the same way that the kind of, obvious pandemic and with substantial national consequences that's happening right now are. The courts are going to be far more reluctant to intervene or to second guess executive decision making, whether it be Democrat or Republican executives, in this scenario. But I don't mean to suggest that there's no route of appeal here, and we can explore some of the other scenarios. But I think we're just trying to be realistic. It's the states under our constitutional system have broad power, and it's difficult to challenge in this type of a scenario.
And you can look back to, for example, the Jacobson case and say, okay, that's a 1905 case, and that's, is that still precedent? But it is, and that case held pretty strongly that there's no constitutional right for a person to be free of every restraint, that basically as a condition of citizenry, you're subject to a form of restraint for public good. And later on in 1945, the Supreme Court, in connection with the vaccination case, again, talked about the state's rights to public safety. And so those are just tough burdens to overcome, particularly when, as I think Matt said at the beginning, this is sort of unprecedented. This is, we're all learning as we go somewhat, not only legally, but also medically, and from a government perspective as well.